Okay, so welcome everyone to our Freedom of Information Act Advocacy Toolkit workshop. We are so excited that you guys are here, and again, we're super grateful that you guys are taking time out of your busy schedules to attend this webinar. When combing through the white paper, Daniel and I found a lot of useful information that we're hoping will be very actionable for our advocacy at the chapter level, as well as the national and international level. So, well, I guess national because it's FOIA, it only applies to the US, but we're really excited to have all of you guys here. And with that, we will take it away. So just for some quick introductions, I'm Rahil. I am on the North America Coordinating Committee and a UCLA alum, and I lead the Access team.
Um, Pretty much the same intro here. I'm Daniel. I'm also on the Access Team Coordinating Committee, and I'm a UCLA UAM alum as well.
So I just added in a couple, I guess, abbreviations just so you guys can follow along a little bit easier. So FOI, Freedom of Information, FOIA, Freedom of Information Act, TTO, Tech Transfer Office, and TTA is Tech Transfer Agreement. And we'll be using Tech Transfer Agreement and license kind of interchangeably here. So, as I'm sure that most of you guys are aware, the main problem or roadblock that we face in our advocacy is that most TTOs, they don't readily disclose the contents of the actual contracts that they have with licensees or pharmaceutical companies in our case. And that's very important for us to know so we can see if they indeed have equitable access provisions within these licenses. And the fact that the TTOs don't readily disclose them, serves as a huge obstacle for us. So the big question, the guiding question of this webinar is what exactly can we do about it? And the answer is freedom of information laws. So public universities specifically are organized under state law. So we can use FOI laws to understand a number of key things that'll then inform the next steps in our advocacy, namely, one, whether there are equitable access provisions, um, as well as the fact, or as well as if the license is exclusive or non-exclusive, um, and a couple of other things as well. And I wanted to, kick things off with this quote from one of the founding fathers, James Madison. The right of freely examining public characters and measures and free communication is the only effective guardian of every other right. So this principle is kind of grounded, is one of the grounding pillars, I would say, of our democracy, that the public has a right to have access to public information, and anything that's done with public money, should be made available and aware to the public. So we have, that level of accountability with, where our money is going and what our government is doing. So just a quick background idea on FOIA laws is the key idea is that they establish a presumption that government records are open to the public. So just building off of James Madison's idea that I mentioned in the previous slide. And for some history, in 1866, Nebraska enacted the first, what I'll call a sunshine law, where it granted citizens the right to inspect public records during business hours. So this was kind of the first official law on the books that, allowed for the public to inspect public records. Then this was scaled to the federal level with the Freedom of Information Act, or FOIA, in 1967. And anyone can use this law to request public records. And then in 1974, the Watergate scandal um, really shifted the culture as well as improved safeguards on FOIA related laws at the state and federal level. And for those of you who don't know, the Watergate scandal was when former President Richard Nixon wiretapped his political opponent, and he was forced to resign after the scandal broke out. And since then, they made stricter requirements on like the timeline to disclose, and how um I guess the leeway that requesters get when they request or when they submit FOIA requests to the government. And then I think there was just a general cultural shift where or the general public was more interested in knowing what was going on behind the scenes in the government. So the big question is, why is this relevant to us specifically? So, the University of California system, they received 570 utility patents, and generally speaking, the University of California profits a lot from patented technologies, and the and pretty much all research, most if not all research at the UC system is funded by the government. So given that we have a public stake in all this research, we should get a return on our investment. So UCLA, for example, got a 1.14 billion cash payment when it licensed the prostate cancer drug Xtandi to Royalty Pharma. And given that Xtandi costs nearly 190 grand per year per patient, it isn't quite the return on investment that us as the public should have. So uh, this is kind of an illustrative example for why the Freedom of Information Act and all of our advocacy work is as important as it is. And with that, I will kick it off to Daniel to explain the California Public Records Act.
Yeah, so I'm going to talk about the California Public Records Act. You can go to the next slide. So this is basically California's own Freedom of Information statute, and they passed it in 1968. It's also known as the CPRA for short. And so basically, the Sunshine Amendment that was added to the California Constitution guarantees that the people have the right of access to information concerning the conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. So that's kind of the core of the official text, basically just showing that the people have the right to know what's going on in public agencies. So you go to the next slide. All right, perfect. So you guys might be wondering, why is the CPRA important? I mean, this is a UAM North America call, so why are we just worrying about California here? And why did Georgetown decide to write about the CPRA in their white paper? Well, UCs like UCLA and Berkeley hold a lot of power, as do other California public universities like Cal State universities and state agencies. I mean, it's just a really huge system. And an example of that is that UCLA and MIT are tied for the top recipients of federal funding for the development of their technologies, binding them to Bayh-Dole requirements that Rahil was talking about a little bit earlier. And considering that these FOI statutes are, you know, they're easier to use in public universities. We're going to get into private universities a little later. The strong public system that California has makes it an important target for us. Also, we do have some UAM presence in California to help with these projects. I know we have some UCSC in the call, so that's nice. And then also UCLA chapter and, others. And also, the CPRA is limited to California agencies, but anyone can make a claim. So you don't have to be a California resident. You don't even really have to be a citizen. Anyone can make a claim to a California agency that the public deserves to know what documents you're looking for. And so now I'm going to get into the steps of a CPRA request. So these are just just like a general outline. We're going to actually send out a letter with a little bit more details on how to submit a CPRA request after this. But so yeah, first you would just contact the state agency and reasonably describe an identifiable record. So basically, you just want to describe what you're looking for. You want to make sure you're being as specific as possible because you don't want to leave them any room to deny your request because it was unclear. So just be as specific as possible and just tell them what you're looking for exactly. Then the agency must assist in identifying and providing the records without considering the reason for your request. So, that's good for us. They can't consider why we're asking for this information. So as advocates, I mean, sometimes people are a little averse to any sort of advocates, but they can't be. They have to give you the information, as long as there's no exemptions, which I'll talk about in the next slide. So third, the agency has 10 days to respond, but they can ask for a 14-day extension. And lastly, the requester, which would be you in this case, would have to pay a copying fee because it's like printed documents typically, or if possible, you can also request for an electronic transfer of the documents. So yeah, ask for the electronic transfer if you can. If not, then the agency might charge you a copying fee for whatever documents you're trying to get printed. But next, I'm going to talk about some exemptions. So these are basically some reasons that a California state agency like a UC could basically not disclose a document to you so they can continue to withhold it if some of these exemptions meet. There are a lot of exemptions, but some relevant ones that I'll bring up include trade secrets, which I'm gonna get into in the next slide later. Personal medical information, so pretty obvious. If there's medical information in any of these documents, it's not something that the public should be able to see. Info related to law enforcement or crime victims, again, pretty obvious. You just shouldn't be revealing that. Social security numbers, official records when designated public version has been made available. So basically, like if there's already some sort of public government version of a document, you can't go and ask for like the document again because they've already kind of made it available to the public anyway. Um, a disclosure that would violate privacy rights enshrined in the California Constitution, and a catch-all exemption. So the catch-all exemption, I'm also going to get into that later, but it's one of the common exemptions that TTOs are going to use as well. Um, yeah, so trade secrets and catch-all exemption, those are the two that the TTOs are most likely to use to basically argue that they want to protect their privacy or that of their partners. And, the one thing that we do need to remember though is that although this kind of seems discouraging, there are a ton of exemptions. The fact that like some parts of a requested document fall under the terms of an exemption does not actually justify them withholding the whole document. So for example, if you're asking for a really big document and maybe, I mean, there would never be patient's medical information in it, but just in case, just as an example, if there's one sort of page that has a patient's medical information in it, then you can just tell them to redact that one page, that one line, and then they still have to send you the rest of the document. So they can't just withhold the whole thing because an exemption applies to just a little part of it. So now I'm going to get into the two exemptions that I was talking about earlier that are basically the most relevant here. So the first one is trade secrets. So basically, TTOs will sometimes claim that they can't give you documents related to their business with pharmaceutical companies in order to protect trade secrets. And, this is not a problem limited to TTOs. This is something that could always happen in any sort of document search. But, as we're UAEM and we're kind of talking in this frame, then that's the frame that I'm going to give you guys. Um, so the California Uniform Trade Secrets Act, or CUTSA, defines trade secrets as information that one derives independent economic value by virtue of its secrecy, and two is subject to reasonable efforts to maintain its secrecy. So all that really means is that, a trade secret is some sort of information that it's more valuable because it's hidden, and there are a lot of efforts being done to keep it hidden. So it's not something that these companies or these agencies want to necessarily just reveal off of a request. And there actually is a little bit of court precedent for this. So in an RE Electronic Arts case, U.S. Court of Appeals for the Ninth Circuit noted that a licensing agreement containing pricing terms, royalty rates, and guaranteed minimum payment terms did qualify as a trade secret, meaning those terms were things that were allowed to be kept hidden because, they found that it was more beneficial to keep it hidden. It derives independent economic value from hiding the pricing terms, royalty rates, etc. Um, so now I'm going to get into some common arguments and rebuttals related to trade secrets. So yeah, as I just kind of told you with the court case, universities do have some validity to their claims that licensing agreements are trade secrets or they contain trade secrets because as I said, like pricing, royalty, things like that, those can be considered trade secrets. However, the argument that we have to make as advocates would be that the CPRA requires you to redact any of those specific trade secrets while still leaving the rest of the document, the rest of the licensing agreement, whatever it is, available to be viewed. So, just because those are trade secrets, that doesn't mean you can't just show us the entire thing that we're asking for. And that's like an argument that we would be able to use against them. Another issue that we might run into is that a third party, which is a subject on the records that are being requested, for example. So, in this case, an example would be like a pharmaceutical company. If we're asking a UC for a licensing agreement, the pharmaceutical company would be the third party, and they could technically sue the requesting party or government agency to keep the records private. So they just want to make sure that they keep their licensing agreements private. However, there is still legal precedence on our side here for disclosing licensing terms between a public university and private entities, which, could be us. And the court precedent comes from the Cal State Fresno versus Superior Court case. So, in this case, the identities of donors who were investing in some luxury suites on campus, obviously not related to TTOs, but still precedent. Their identities were revealed due to it being in the best interest of the public to know where their tax dollars are going. So, yeah, basically that just shows that, there is some sort of precedent here for disclosure. So that does help us. And then the next thing that I want to talk about was the catch-all exemption. So the catch-all exemption, basically means it's very vague, but it allows the California State Agency to deny production of records after determining that public interest is best served with non-disclosure. So, yeah, as you can see, that's pretty broad, but it just shows that they can technically deny you a document if the public is better served by hiding the document. Some easy examples here are like nuclear codes, secret agent identities, etc. Like these are things that do not need to be out in the public. These are things that are better off staying private. Those are some obvious examples just to, have you understand what the exemption is. But California courts do interpret this as a case by case type of thing because it is very subjective, Who's to say what the public interest really is and like how it benefits from what, right? So the courts will just identify and interpret this on a case by case basis, whereas the advocate of non-disclosure, so in this case, the university, right? Whoever doesn't want to disclose documents, that advocate must demonstrate a clear overbalance in favor of confidentiality. So basically, the university is going to have to show the court that there's a very clear amount of evidence that shows that it's better off to keep the document hidden. So that is helpful because the burden of proof is not on our side here. We don't have to prove anything. The university is the one who has to prove that, it's better to withhold this information. And so it does help us in that case. And there's also something called deliberative process privilege that does also fall under the catch-all exemption. So what that is, it was in place to protect policymakers, and basically it applies where a disclosure of the materials would expose an agency's decision-making process in such a way to discourage discussion candidly within the agency and undermine the agency's ability to perform its functions. A lot of text, but basically all that really means is that it's important to disclose these documents if they reveal, the candid discussions of an agency and if they reveal the deliberation process of an agency. So, an example of this is that the court upheld non-disclosure of the governor's schedule and calendar over a 5-year period due to deliberative process privilege. So, in this case, someone had asked to see the governor's 5-year schedule, and the court ended up withholding it because they decided that, the governor's inner workings, the meetings that he takes, whatnot, like those are things that don't necessarily need to be out in the public because it would discourage him from candidly accepting other types of meetings, et cetera, et cetera. So just anything that kind of reveals like someone's inner thoughts and will hinder them from, truly acting on it that's basically goes under deliberative process privilege. So I'm going to go into some issues with the catch-all exemption and then more specifically the deliberative process one. I know these slides can be very text heavy and I'm talking a lot. I just wanted to make sure to have all the court precedents on here on this physical slide so that if you're ever watching the recording and coming back to it, that you can see what you need to see. But so for this one with the catch-all exemption, the court precedent comes from the case, the Humane Society of the U.S. versus the Superior Court. So, the Humane Society sought records regarding funding, prep, release, and publication of a government-sponsored academic study called Economic Effects. But the court found that disclosure of pre-publication communications would impair the research process. So basically, just to sum that all up, what kind of happened was the Humane Society wanted to know all the different, discussions of the government sponsored group, and they wanted to know everything that happened before this publication of this research document. And the court said no because they thought that it would hinder the research process by showing, what these people were thinking basically before anything was published. But for us, that precedent doesn't really apply for us because we can just argue that TTOs aren't really transferring the rights of any technology that hasn't already been published. So basically, no deliberation here is being revealed. It's just we're looking for the rights of something that's already done. We're just looking for a contract. It's not going to reveal any sort of thing about the inner workings of the TTO to the public. In addition, TTAs or tech transfer agreements don't reveal the intricacies of academic research, rather, only enough information to just define the scope of the IP rights being transferred. So, again, similar thing. It's like we are only looking here for the final product. We just want to see the agreement. We don't really we're not asking for anything that happened before. We're not asking for details about the research. We're not asking for any of that. So, this catch-all deliberative process type of argument doesn't necessarily apply to what we are doing. Because as you want to keep in mind, the general principle here is that the public does have a vested interest in knowing how their funds are being used when it comes to publicly funded inventions. That's just the common thing that we need to keep in mind and always bring up because that's something that the courts do have to agree with. And then I'm going to talk about another deliberative process argument. So, universities could argue that disclosure would undermine the process of efficient tech transfer due to revealing their deliberation processes. Basically, if they want to cite that they don't want to give you the licensing agreement because of the deliberative process portion of the exemption. Yes, we should argue that a contract is not a deliberative document. It's communications made after the deliberation has already happened. And the court precedent here is that in ACLU of NorCal versus Superior Court, the California Court of Appeals found that the disclosure of pharmaceutical suppliers would not expose the mental processes of any government employee or the substance of deliberations relating to the formulation of any government policy. So yeah, basically the court cases back up everything that I was just saying. The, licensing agreement or knowing the pharmaceutical suppliers rather doesn't show anything about the mental deliberation processes that happened beforehand. Okay, so I just talked a lot about a lot of the arguments and things like that. But now here's back to more logistical information. So this is for UC. So the guidelines that the UC has when you're trying to submit this type of request, the CPRA request, the UC Office of President's guidelines indicate the following. You have to provide specific information about the records and describe any unnamed records as much as you can. So just, if the document you're looking for doesn't have a name, just give as specific and as clear of a definition of whatever you're looking for as you can. Ideally, the request should be written in email form. Copying costs UC wide are going to be 20 cents per page. So if you are looking for a document, that's how much they're going to charge you if you have to end up printing it. But hopefully you can request electronic transfer and then you wouldn't have to pay anything. And also, if you don't want to pay anything too, a requester can also inspect records prior to duplication during business hours, meaning you can basically go in and look at whatever records you want before they copy them and give them to you so you don't have to pay the fee. And then now this is just a chart that shows how responsive some UCs are with the CPRA request. This is straight from the Georgetown white paper. As you can see, the UCs are not the greatest at responding. They take very long. The average response time ranges anywhere from 43 to 393 days, which is crazy considering that, as we talked about earlier, they're only supposed to have 10 days to respond to your request, and they can ask for a 14-day extension. So really, this number should never be above 24. But clearly, the UCs find a way somehow to take forever to do these things. So just keep that in mind if you're ever trying to submit one of these requests. It might take a while. The approximate success rates are also listed there. So if there wasn't a success, that means the UC was able to keep the document, confidential. So those are the success rates, but hopefully with the knowledge of the common exemptions that TTOs might bring up, we would be a success. You guys wouldn't have to fall into the poor part of that statistic. And the sample size here is also shown, so a decent amount to go off of. And then the last thing I'm going to talk about is going to be the recourse process. So this is basically like, all right, you do all this. What happens if the UC says no, or if any state agency? What happens if they say no, they're not going to show you the documents? So unfortunately, there's not a process for administrative appeal. So, there's not an internal UC process that you can kind of go through to do it again. The wrongful denial, you must sue in a state court, and courts will grant discovery requests when necessary to resolve whether or not the agency has the duty to disclose the document. So basically, it has to go to court, and courts will end up granting the request if it is valid. So, hopefully the UC will see if your request is valid and you won't have to go through this position. And yeah, the petitioner will be refunded legal expenses if you win. So all this is kind of to say you don't want to be doing this. Obviously, you don't really want to be going to court. You don't want to have to go through recourse, meaning make sure you're being as specific as possible with any of your requests, just to avoid having to go through any of that. Just know exactly what you want. Make sure that, in your mind that it doesn't violate any of the exemptions, and just, be very specific with them of what you want. And then you shouldn't have to go through recourse. But yeah, that was the whole section on the CPRA. We're going to end up emailing you guys with some information on how to submit the document and some other important factors to consider, but it's kind of the CPRA in a nutshell.
All right, thank you, Daniel. And one quick thing before I jump into private universities. Um, Obviously, all of that was about the California Public Records Act. So if you are in a different state, make sure you kind of do a little bit of digging and understand your state's freedom of information laws and what that would entail. But the principle of being as specific as possible with your request still applies. And again, if you guys have any questions, feel free to email us or message us on Slack. Our email will be at the end of this presentation. So we'll jump into private universities now. So freedom of information laws are sadly or they're inapplicable directly to private universities. So, if you're from a private university, I'm sure you're asking, what can we do? And we will get to that. Well, the first slide that I'll present is certain arguments that you could make for getting licensing agreements between private universities and licensees. So the first argument is that the Bayh-Dole Act creates a public stakeholder in publicly funded technologies through the establishment of margin rights. So there's a provision within the legislation itself that states that if a publicly funded invention is not being made commercially available, or as the legislation says, utilized properly, or there aren't efforts to make the invention uh, you know available, then the government has a right to quote unquote march in and take a license for itself and then make the invention publicly available. These have never been used before, and there have been four petitions to the NIH to have the government or to have the NIH march in and make a variety of different drugs cheaper by exercising its march-in rights, and each time the director of the NIH has refused to do so. And then the second argument, and this is in context of the CPRA, perhaps other states have some similar wording in their legislation, um, but an agreement between pharmaceutical companies and private universities relates to the conduct of the public's business, so as long as the research from the private university or the product developed from the private university with funding from a government agency, so like the NIH, the Department of Defense, NASA, to name a couple examples, that would be fall under that public business portion of that legislation, or sorry, of that law. Um, and then, although these are arguments that we could make, there isn't any sort of direct legislation that helps us. So this is from Section 200C5 from the Bayh-Dole Act itself, where they require, in this case, universities to report on utilization or efforts at obtaining utilization of the federally funded invention. So these reports, these utilization reports, are exempt from FOIA requests because it's considered classified as financial slash commercial information. Um, and the reason for that is if these were, not exempt from FOIA, competitors could then use FOIA to request that data and time their market strategy and other business practices to gain an unfair competitive advantage um, based on whatever utilization reports that a licensee or a university would have. So if an agency invoked this legislation to deny disclosure of tech transfer agreements, we would argue that TTAs are not utilization data, but they provide the framework for how, or framework for the utilization itself. So whether or not um, this invention will be licensed to one specific company or if it's non-exclusive, all of that isn't really data on how, like how the university is trying to utilize the invention. It's rather just the framework by which they will utilize the invention. And then the president of the American Patent Association, I believe is the name of the organization, Donald Gunner, had some concerns about this a while back and how, disclosure of TTAs would involve the disclosure of technical data. But as Daniel mentioned earlier, the agency could just redact that information as its proprietary information and then leave the rest of the document unredacted for us to see. And we don't necessarily need the technical data for our advocacy anyway. We would just need things like if they have affordable access provisions, what kind of license it is, if they're compliant with their own model licenses on their website, things like that. So just a little bit of background info. Now we can get into the fun stuff. So one way that you can get some sort of transparency or some sort of understanding between, your private, if you're at a private university, your university, and a pharmaceutical company is through SEC filings. So these filings would reveal the existence of a licensing or a collaboration agreement. So while you would get that information, we don't have any control over what information is disclosed. So it's kind of a luck of the draw and how willing is the licensee or how willing is the licensee to disclose like certain provisions of their licenses and other stuff. So there's this amazing website called the Global Healthcare Innovation Alliance Accelerator, where on this website they have a database of a ton of different agreements that they were able to find via SEC filings. And the link is on this slide, and we can also send it out or put it in the chat. But the two types of forms that are going to be quite instructive are 8K and 10K forms. So what an 8K form is that it notifies shareholders of specific important unscheduled events that could affect the stock price of a given company, and these apply to publicly traded companies only. And then a 10K form is an annual report outlining a company's financial performance. So it would include kind of a summary of these material events as well as just um, other financial data that the SEC requires publicly traded companies to disclose. So here is kind of an example from the GHIAA website. This is the actual language from an equitable access provision in an agreement for a cancer therapy that Yale and Biosciences collaborated on. And as you can kind of see here, that it literally says it is the desire of both Yale and licensee to make licensed products available in the developing world. And it is the parties' common desire for the licensee to develop licensed products that are clinically and economically suited for use in those areas. So it's and so on and so forth. But in summary, they really want to make an effort to make things more affordable in low and lower middle income countries. And they do say later on in that license that they aren't going to enforce the patent in these types in those countries, which is obviously great to see. And then this is the next couple slides will show you the SEC website and kind of how to look up this information. So I know we're kind of reverse engineering this whole process, but if you just look up, sec.gov/search filings, you can put in the name of the company, Bind to Biosciences, and in that you get a list of all these different filings. And then in the top right corner here in the keyword section, I would put Yale just to sort of see um, any of the agreements between the university and the company itself. And then, oh, whoops, did not mean to click that. Oh, there we go. So in in these 8K file, like you can kind of see that there's 8K filings here, and in those documents it outlines it would mention Yale University um entering into some sort of licensing agreement with Biosciences, and licensing agreements would fall under that unscheduled material event that I mentioned earlier that would necessitate the filing of that 8K form. And then another way that you can get some transparency is the USPTO patent assignment search. And this can be used to identify patents that are subject to the Bayh-Dole Act. So, inventions that were developed with federal funding. You can investigate a patent's ownership chain, and you can find information about licensees, although that is kind of rare. So using Xtandi as an example, the compound name, Xtandi is the brand name, and enzalutamide is like the main compound within the drug. So if you search that up, you can kind of see a ton of different results in this search. And this is an excerpt from the last page of results where we kind of see the first agreements of licenses or assignments of patents to Astellas Pharmaceuticals as well as Medivation Prostate Therapeutics Incorporated. So these are two companies that had the earliest licenses for Xtandi. So that allows you to understand the relationship that, okay, UCLA licensed out Xtandi to these companies. And then this the next two slides are what a patent assignment cover sheet looks like. So um, if we were to click, the publication, it would hyperlink to, this cover sheet. And this is actually the patent for CRISPR. So Dr. Feng Zhang at Harvard licensed out CRISPR to the Broad Institute. I'm actually not sure if, the conveying party is from Harvard. I forget which university they're from, but they licensed it out to the Broad Institute. And then looking here is the exact text of the patent assignment itself. So I know it's a lot of language, but it's kind of cool to see that, these patents are available for us to see on the USPTO website. So just to recap, there are these two different ways that you can get transparency if you are at a private. I mean, this is also applicable to public universities, but this is the best way if you are at a private university at understanding the, relationships that, your university has with different licensees. So I know that was a lot of information, but we really, really appreciate your guys' time and your energy, paying attention to us for this long. I know this was quite a lot of information, but we really hope that this can kind of kickstart some sort of advocacy at your universities regarding, certain drugs or compounds that were licensed out to pharmaceutical companies that may not have included equitable access provisions or some of the stuff that we're fighting for in our work. So if you have any questions, feel free to email us at access@uam.org, and we'd like to just open the floor for just general questions.
Yeah, I had a question about the responsiveness, the Freedom of Information Act responsiveness. I was surprised to see UC Berkeley success rate so low because they seem to be like so open with their I don't know what to call them, plans, policies. Yeah, is there a reason for UC Berkeley to be so low on the success rate?